It's been a while. Hello, everyone. Good evening. I'm Thrishi Goyal, and I'm a research fellow with the Center for Applied Law and Technology Research. I want to extend a very warm welcome to all of you, and thank you for taking out time to be with us today. As we all know, the JPC, the Joint Parliamentary Committee, has recently published its report on the Personal Data Protection Bill 2019. Now, given the imminent introduction of a law on data protection, it is an opportune time for us to take a critical look at some of the defining concepts by the under the PDP bill. In this regard, the Center for Applied Law and Technology Research at PDP is publishing a series of working papers on various aspects of the PDP bill. The first working paper discussed the need for retaining informational autonomy in the age of emerging technology. The second paper now focuses on the issue of children's informational privacy. The discourse on this issue is still at a nascent stage compared to the other more visible issues that have been highlighted in the law's almost 4-year journey. But the regulatory response to this issue requires serious consideration because it will have significant implications on children's right to privacy, right to access the internet, and also their right to autonomous development. Simultaneously, it will also have far-reaching impact on the data processing architectures of data fiduciaries. To deliberate on India's regulatory approach on children's privacy, we have a distinguished panel of speakers today. We were supposed to have Mr. Gaurav Gogoi, but unfortunately, he's unable to join at the moment. So we'll still start the discussion. First, we have Dr. Elizabeth Coombs. Dr. Coombs is currently an affiliated associate professor at the University of Malta. Her formidable body of work as an academician, practitioner, and a regulator has contributed significantly to the discourse on privacy and data protection. She was formerly the chair of the task force Special Rapporteur to Privacy and has also served as the New South Wales Privacy Commissioner. Thank you, Dr. Coombs, for factoring in the time difference and being with us here today. From the industry, we have Mr. Sunil Ibrahim and Ms. Uttara Ganesh. Mr. Ibrahim is currently the Public Policy Director for Facebook India. He co-founded the Center for Internet and Society and is really sort of the initiators of civil society discourse on digital issues in India today. His perspectives from both the civil society and industry places him in a unique position to provide regulatory solutions that are rights enhancing and also effectively enforceable. A very warm welcome to you, Mr. Ibrahim. Ms. Uttara Ganesh is the public policy head at SNAP. She has previously worked with parliamentarians and also the industry on issues of data governance and child protection related issues. SNAP today is arguably the most popular and widely used application among children. And therefore, its perspective on data privacy issues relating to children is highly relevant in furthering this discourse in India. From civil society, we have Ms. Aprajita Bharti. She is the co-founder of Quantum Hub and YLAC. YLAC is Young Leaders for Active Citizenship, which has emerged one of the foremost civil society organizations working with children today. Her extensive work with children spreads across multiple cities and gives her insights on how children interact with the digital environment. In fact, in the Indian space, she has been one of the torchbearers of this issue. And thank you for joining us and bringing that democratic element to this discussion where, we're able to understand children's point of view of the digital environment through you. I'm going to outline the format of the discussion. We will first have opening remarks from the discussants for around 3 to 4 minutes each. That will be followed by a moderated discussion around some themes on the issue. So I will now, in the absence of Mr. Gogoi, I will open with you, Dr. Coombs. Um, what do you think are the basic founding principles of children's privacy? Because laws may differ from country to country, but there seems to be running through them a common theme, uh, which is foundational in its very nature. So if you could, in a few minutes, elaborate on that.
Certainly. I do need to start my comments, though, with a very sincere thank you for the opportunity to participate in this event and with this panel of experts, practitioners. It's a wonderful opportunity, as I was saying just a few moments ago, to reconnect with India, given the restrictions that the COVID pandemic has placed on all of us meeting in person and the opportunities to travel, because to travel to a country is a very different experience from discussing matters on Zoom. So I look forward to returning to India. Also, as part of sort of my preliminary background comment, is I'm really delighted to see India moving ahead with the introduction of a data protection bill. I mean, as the world's largest democracy, it's time and there is need for this action. It's the era that we've seen, and particularly the effects of the post sort of period after the pandemic, particularly in the area of children, are really significant. Never before have children been isolated to the extent that they have and dependent, where they have access to the internet. And, not all children have access to the internet, but where they are, the reliance upon the internet and the digital world has really brought to the front of our minds, the need for protection of their autonomy and their ability to develop as individuals, but also of their informational privacy in particular. So the points that I would like to make, and I want to acknowledge the point that you've made very clearly and well in your working paper, and that is about the need for India requiring a data protection framework that reflects India's circumstances, rather than people expecting India to pick up a jurisdictional approach, say from Europe, the US, South America, or wherever else. It needs to reflect India's circumstances and needs, and I strongly support that aspect. However, having said that, I'm going to approach the topic today from an international human rights perspective, and I do that feeling quite confident in that India's constitution recognises children as the equal bearers' rights in the fundamental rights section in the same way that adults do. And I felt that this is a really significant aspect. Bear in mind that I'm from Australia, where our constitution does not go to the issue of citizens' rights. So when I read the Indian constitution, I'm very impressed. And I also noted, in particular with regard to today, how children are treated. But India has ratified, in addition, in 1992, the United Nations Convention on the Rights of the Child. And that also, I think, is significant, particularly when you read the periodic reviews that have been made to the Committee of the Convention on the Rights of the Child. Those things, particularly in combination with the Puttaswamy decision of 2017, make me feel that it is okay to be speaking from an international human rights-based principled approach. And that perspective that I'm bringing today, where I do not claim to be an expert on India's circumstances, challenges, or even all of the laws that you have which relate to children and to data protection privacy, but the work that I did as a task force chair to the United Nations inaugural Special Rapporteur on the Right to Privacy, which included work on the importance of privacy to the development of the individual, the work on privacy and gender being an inclusive term, not just relating to women's situation, but also, and particularly most relevantly for today, is for the work on privacy and children, and then my own subsequent research since then. Now, my more in-depth comments when we get onto some of the particular questions that you want to raise will go back to the International Convention on the Rights of the Child. And the sort of 4 points that I particularly want to raise is what is meant by the child and how a child is a bearer of human rights, the right to privacy and how that enables the enjoyment of other human rights, chronological age as a mechanism for assuring access to rights and also to services, and then that concept of the best interests of the child. I hope that's sufficient in terms of introductory comments.
Yes. Thank you, Dr. Coombs. I think you outlined very well the kind of rights-based framework that we have surrounding children. But the real question is whether that rights-based framework is translating into our PDP bill today. Those concepts of best interests and chronological age and child as a right bearer, while we do have that in our foundational laws in terms of the Constitution and the UNCRC, the question before us, and we will explore this as we go, is how well is it translated within our domestic statute?
I understand that the opportunity to address those particular issues will come up later after we go through the other members.
Yeah, we'll just finish off the opening remarks and then we'll come to these issues individually.
Thank you.
Thank you, Dr. Coombs. Mr. Ibrahim, next to you. Could you just, after Dr. Coombs, outline of the international perspective, just in that context, give us an understanding of the provisions under the PDP bill and, what are the main facets of children's informational privacy in that proposed law?
Let me also thank, first beginning with the organizers of this panel, Vidhi Center for Legal Policy. Very grateful that you have invited me to be part of this panel discussion with all these distinguished panelists, people who know much more about the law, given that I don't have any legal training. I wanted to perhaps continue on the various threads that Dr. Coombs had introduced into the discussion. The first is the harmonization imperative within the Indian context. The way India for a very long time now has been ensuring that domestic laws are harmonized with global and international human rights instruments. The second, the important point that Dr. made about children being equal bearers of rights. And finally, the observation that she made that there are still so many children that are not online. And that very same observation could be expanded to say that there are still in the Indian context so many adults also who are not online. And at this point, I want to make a small digression autobiographically into my own experience when my father bought me my first 386. This is 1992. And then I borrowed a modem from a friend. And we got online connecting to the various BBSs that were operating in the Indian territory at that point. It is only 1995 when the public internet was launched within the Indian context by BSNL then. So at least as far as my own experience goes, it was me as a near child. I was 19 at that time, so not really a proper child, who brought the rest of my family online. And I believe that when we look at the digital divide in the Indian context, this is precisely what is going to happen. It is the young folk who are going to bring their parents and grandparents and the rest of the town or the village online. And this core contribution that young people and children are going to play towards bridging the digital divide should not be discounted or underestimated. This should be a key consideration for us as we enter a discussion around the design of the protection of children's rights in the PDP. I will make two very broad observations about the approach that the PDP takes. The first approach is that the PDP has decided on a broad brush approach to protecting children's rights. So it appears as if a small set of obligations will be equally applicable to all service providers that are providing services to children. The trouble with this type of approach is that the services are dramatically different today, and the risks for children are also very different across these services. So ideally, what India should be doing, perhaps I noticed that the MP has joined us. Good evening, sir. Thank you for joining us.
Thanks. Sorry for joining late. Please continue.
So what I was trying to say is that either the law should allow for a co-regulatory regime like the GDPR, where subsidiary regulation can be much more granular when it comes to protecting the rights of children, or alternatively, something like the UK age-appropriate design code, where there are different tiers of protection for different age groups, whether you're 0 to 5, 6 to 9, etc., etc. So that would be the first observation that I'd like to make, that we need to have a much more granular approach, which is both domain-specific and age group-specific, to do a better job of protecting children. The second is, it appears as if the approach to protecting the rights of children is a data maximalist approach. So platforms are expected, for instance, in order to verify the age of the child, and also in order to verify that a particular person is indeed the parent of the child, to collect ID documentation from both parent and child. But usually data protection laws emphasize the principle of data minimization. So there seems to be a foundational conflict in the approach to protecting the rights of children with the data minimization principle. So I'll stop here with a very broad observation.
Thank you, Mr. Ibrahim. Those were very pertinent observations. I'll comment on those later. I'll just welcome Mr. Gogoi first to the roundtable discussion. Good evening, sir. So just by way of brief introduction for you, we now have Mr. Gaurav Gogoi, who's joined the panel. Mr. Gaurav Gogoi is currently serving his second term as Member of Parliament. He was also a member of the JPC on the PDP Bill. And if I might add, he submitted a rather incisive and well-drafted dissent note to some of the key provisions of the bill. Mr. Gogoi's contribution to governance structures and legislative formulation will help us give today an unparalleled insight to inform our approach on the policy issue at hand. His prowess in data governance also stems from his previous extensive experience with the ICT industry. Thank you, sir, for taking out time and being with us here today. Sir, so just to bring you into the fold of the discussion.
Yeah, go ahead, Trish.
Yeah, so sir, to bring you into the fold of the discussion, we would very much like from you to have a perspective, a legislative perspective of, what were the legislature's concerns that formulated the position of the law, which we see now, which is being proposed.
Thanks, Trishi. Again, apologies for being late. I got a bit of what Sunil was saying, and I had the chance to look at your paper earlier in the day as well, Trishi. So well done on that. Having been part of the JPC, and you know that the JPC sat for a very long time. We had two chairpersons, and we actually went quite into detail as a result of this period into each and every clause. But I must say that um, you know, now in hindsight, okay, I wouldn't have said it then because I was in the midst of everything. But now in hindsight, I would say that this legislation, and I'm not speaking of the clause chapter 4, clause 16 specifically, but overall the approach to the legislation now in hindsight and taking advantage that we are speaking in a closed door forum and
This is not close to just to
okay.
point out.
So I would say that this government, that there could have been much more thought into some of the specific sections of this legislation. Because when we started this legislation, when this exercise was started, the exercise was started with a very simple intent of protecting privacy. And what the approach that the government used was the approach of consent and data fiduciaries. But uh, several factors contributed to this bill being omnibus and really being extensive and going beyond managing privacy to managing data to managing social media. And unfortunately, the direction that was taken during the committee, again, many factors contributed to that. Instead of taking a step back, we took a step even to further to expand it, the outreach of this bill, and to even look at non-personal data as well, and treat this bill as as a comprehensive data management bill. Now, I think that's where fundamentally we have gone away. We've made a fundamental flaw in terms of design, is that the objective was privacy and the design turned out to be data management. And they are two different schemes. So therefore, I see a lot of chapters in which we could have gone into much more detail if we were to come out with a comprehensive legislation. But not having the benefit of that, the language remains as may be prescribed later, as may be prescribed by regulations later. So as if this is bill chapter number 1, and there's another, if this bill were to become law, we'll again have to look at rules, and that's where the real stuff, the real meat of this regulation would be, and then that is left to the executive and to the interplay between the central government and the DPA. So I really feel in hindsight that uh, we should have been a bit far more concise and precise. And had we been, and if we were going for a comprehensive data management bill, then we should have been um, far more comprehensive in our homework. I don't think the government did enough homework, and therefore left many clauses to be prescribed in regulations later. Now, coming to the part on children, there were many such concerns, and obviously, if you understand, from the perspective or from the framework of a policy maker, the framework of a policy maker is always to protect and to be extra defensive, and to treat anything outside the government with, let's say, with the frame of mistrust, if I were to put it like that. And that's the policy maker's worldview, if you can say so. So therefore, the negotiations and the consultations that we've had, really painted the sector in a very stark light, as if the sector is out to manipulate children, profile their data, exploit their privacy. Uh, some of it is also I would say, as a caveat, a bit fair, because I also come from a marketing background, and any marketer knows that children are the best influencers. And I used to work in a mobile in a mobile company, and we were looking at database services back in early 2000 when data was still expensive, and the constant aim was to understand children, and through the children influence the purchasing decisions of the parents. So I know children are especially, but at least I know that marketers are especially targeting children. And it is mentioned in your paper as well, and in the years to come, we can't look at technology that is current now. We have to look at technology which is 10 years down the line, technology which is 15 years down the line, when you'll have all sorts of technology and data, your bio data, your wearable technology, all these kind of other devices and platforms, and which will take a lot of data from children. So therefore, I think the policymakers are very protective and have this view that this conventional view that as long as the parent is giving consent, everything is fine. It's not as if the parent's consent is an informed consent, but that's the only check that they are doing, which is that the parent says yes. So in a way, it's outsourcing responsibility. And again, this is such a broad uh, theme that this chapter could have been much more broader. I mean, much more comprehensive. Clause 16 and with its subsections could have been much more broader. The report does make certain suggestions that let's not have guardian fiduciaries, and every fiduciary should have the same responsibility, whether they are not a guard. It doesn't matter if they're a guardian fiduciary. Everybody should have the same set of standards vis-a-vis children. And all of this can be debated, but at this stage, I look forward to seeing what the government does with the report, and what is the version of the bill that they bring in. How many of the recommendations do they accept? Or, after so much of extensive consultations within and outside of government, does the government in fact come in with a totally new bill? That remains to be seen. So with that, I would like to close my opening remarks. Thank you.
Thank you, sir. I think they're very insightful as to the policymakers' approach, as you mentioned. And I think we see that translating in this provision, at least, which is to be extra defensive. As Mr. Sunil was pointing out, there are instances where children are the one who bring the internet home, so to say, right? They are the ones who are more informed in the digital space. But this extra defensive approach sort of throttles that kind of autonomy which children could have been afforded given the present circumstances. I would like to bring in you, Ms. Bharti, here. So we've heard Mr. Gogoi's views on how the committee is the bill seems to be extra defensive. Can you juxtapose that with the kind of experience you've had with children's interaction in the digital environment? What do they use the internet for, and whether this sort of approach makes sense in that context?
Thanks, Rishi. Thank you so much for bringing me into this discussion. Before I think, give my thoughts on, what we are doing with the bill and where I think we are going wrong, I just want to say that, I wear many hats when I come to such discussions. At YLAC, we work with children between 13 to 18 years of age, where we are working with kids in urban centers where, they are extremely aware and very, very suave when it comes to using technology. I'm sure any of us on the panel do not meet their digital skills. But we also work in tier 2, tier 3 cities on digital citizenship, digital literacy programs. And, we are working with affordable private schools. We are working with government schools where we are delivering such content on digital literacy. And on the other hand, I have my policy consulting firm, which is the Quantum Hub, and there we work with tech companies and advise them on, policy. And PDP Bill is something that we chew a lot on just by the nature of our work. The reason why I'm saying all of this is, and also at YLAC, we used to use, advertising on Instagram and Snapchat to reach our target audience so that they can enroll for our programs. right? So I kind of see this problem from many dimensions. I just wanted to lay out that upfront. And I think the heart of the matter in all of this is, who is the child who we are trying to protect, right? Is that child 13 years of age, 14 years of age, 16 years of age, 18 years of age? Is that child in a big city, in a small city, in a government school, in a private school? What kind of parents do they have? What is the gender of that child? So I think one of the main things that is really missing from the entire discussion around this, privacy of children in the Indian context is the best interests of the child. And knowing that all children come from different contexts and different circumstances. And as Dr. Coombs said, that we have to develop a policy that makes sense for India. But India is not homogeneous at all. It is one of the most heterogeneous societies that we have right now. So I think one of the things that we are missing, and in fact, the UNCRC also says, right, when it talks about privacy. And I was actually very sad to see in the JPC, to be very frank, in the report, that there is no discussion around best interests of the child. There's only discussion around whether this law, how does that law kind of interplay with the Contracts Act. Contracts Act says 18 years of age, and therefore we've gone ahead and said that let's keep the age at 18, but that does not really intersect with the society that we have right now. So I think that is something that is missing from the debate. And I do agree with Sunil that there is a lot of discussion in different geographies now, and very, very mature discussion around how children's privacy needs to be treated online, which is very cognizant of the fact that anyway regulation or a consent-based framework will not just achieve privacy or security of children as we want. I think there needs to be a lot more discussion around product design itself. For example, the age appropriate design code talks about default settings, etc. And I think for example, Instagram has just turned, all children's profile are private by default. I think that will probably achieve a lot more for children's privacy than, what any legislation like the PDP bill in its current form could achieve. So I think we need to move away from this parental consent and think a lot more about product design and the best interests of children, and how we define that, and how we lay the onus on product designers and platforms to see in their context, because there are unlimited use cases. And as Mr. Gogoi was saying, that we have to think 10-15 years ahead. So we cannot keep changing this legislation every time, bring it back to the parliament and go through the legislative process. So we need a framework that is based on certain standards and principles, but something that is flexible enough so that it can be adapted to all kinds of use cases and all kinds of advancements in technology, and also balance children's agency with their privacy and security. I can talk a little bit more about that, but that's what my opening stances.
Thank you, Ms. Bharti. That was, I think, we do have a lot of common issues with the way the bill is currently, approaching children's privacy. But you made an interesting point, and as did Mr. Ibrahim, on, the design aspect of these applications, the design aspect of platforms. And I think that is a good segue to come to you, Ms. Ganesh. We've always heard that technology can be an equalizer. Do you think, through these ways, where we're questioning who is a child, do you think those kind of differences can be solved, can be at least mitigated through design and platform features?
Sure. No, thank you, Trishi, for that question. Good evening, everyone. My name is Uttara, and I head public policy for Snapping, the company that owns Snapchat in India. First off, congratulations to the team at Vidhi. You've put together an excellent working paper, and I suspect this is the first of its kind focused on children's privacy in India, contextualized to the PDP. And this will obviously help create a much more nuanced and informed discourse on the matter. I'd also like to thank you, Trishi, for inviting me to participate in this discussion. Super nice to connect with colleagues, although a part of me does wish that we did this in person. With regard, going back to the discussion, right? So there's obviously a lot of complexity that one has to grapple with when considering questions about children's privacy. And we at Snap are keen on dialogues like this that allow us to come together as an ecosystem and delve into these questions. So, I concur with a lot that has already been said by Dr. Coombs, by Sunil and Aprajita. Broadly at Snap, we welcome the bill and we strongly support the need for a context-specific yet globally interoperable law, right, and a data protection framework. But I thought I'd use this time to level set on where Snap's head and heart is at on the issue of children's information privacy, and broadly, maybe you could get into the specifics of the data protection bill later in the discussion. But to your question on design, Trishi, I just want to say that, while privacy laws are welcome and much needed, we believe that design choices are a powerful way to ensure both the privacy and safety of our users. And sometimes, as we all know, making these specific design choices may throw up questions about a trade-off between higher user engagement and privacy. And at Snap, we believe in ensuring that we tip that balance in favor of privacy, right? I've been in the company about 7 months, and candidly, this was a refreshing discovery for me. It is really striking to me how privacy and safety by design and a privacy-first data management practice, for instance, when practiced in earnest, can have a really powerful effect, right, on preventing the types of failures that regulations try to solve for after the fact. So, we can maybe get into the details of exactly how Snap, for instance, achieved that during the course of this discussion. But I'd like to talk about one key aspect of design that underpins this focus of privacy and safety, at least on Snapchat, right? So at this time that Snapchat was being built, we learned from the experience of social media companies. And frankly, there was a deliberate focus at the company to build Snap as an antidote to social media. Okay, so what does that mean? The design of Snapchat, as you see today, has been strongly sort of influenced by existing regulatory frameworks that govern like broadcast and telecoms broadly, right? So that's why when you open the app, for instance, you open it into the camera as opposed to a feed. And then you notice that there is a clear demarcation between parts of the app where you're communicating one-on-one with friends or family. Okay, so this is the chat and the maps part of the app. And the parts of the app where you're consuming entertainment or news, which is our Discover feed, or expressing yourself as a creator, so Spotlight, that has been completely separated. Right? So this architecture intentionally separates social content created by friends from media content that is created by celebrities or creators, right? And there's also sort of built-in safety and privacy mechanisms for each of these specific tabs. On the chat side, for instance, ephemerality is a big one, right? This sort of is a privacy-leaning feature that allows for people not to have a long record of what they've said to each other for eons. Then also, in order to chat, you need to sort of mutually add each other on the app to communicate. There's no way that a stranger can just, speak with you on Snapchat without them having added you and you have consented to their, accepting their request, for instance. There's also a private by default setting on Maps, which ensures information privacy. And on the Discover and the Spotlight parts of the app, right, which is where I mentioned there was more content or publisher content. It's only content from pre-approved syndicated publishers, right? So there's no, in a sense, there's no possibility of fake news, for instance, making its way into Snapchat. And on the Spotlight part, where creators express themselves through videos, we do the old school thing, right? And we ensure that a piece of content, before it hits like the low threshold of 26 likes, it undergoes human moderation. Right? And this ensures that the content is safe and in compliance with our guidelines. So really, these intentional app design choices are combined, again, with data management practices at the back end, things like data minimization, deletion by default, and a way of targeting ads that does not use PII, right? So these are also sort of part of the way we've designed our app. All of this together, to my mind, fundamentally differentiates us from other platforms and has a powerful and preemptive effect on, the safety of our young users. Right? I'll just end with one more point. I couldn't agree more with Sunil about how, the DP bill itself is a bit too one size fits all, right? The bill just simply does not take into consideration the innovative diversity of business models we see in the digital world. Frankly, the phrase social media to me strikes me as a bit of a lazy term, right? So unlike telcos, for instance, which at the back end have the same business fundamentally, and perhaps there's only innovation on it from a pricing perspective, Meta looks different from Reddit, looks different from YouTube, looks different from Discord, looks different from Snapchat, right? Everybody has a pretty distinct app design and value proposition. And to this extent, the children's privacy provisions in the bill do seem a bit all-encompassing and one-size-fits-all. I do know that you set up some time separately to go into the bill itself, so I'll pause there, but thanks again. That was what I wanted to say to open the conversation.
Thank you, Uttara. We will catch up on that point on, treating all services also homogeneously, all online services providers also homogeneously. But let's start with the basics. I think one of the key things that has emerged from all of our opening remarks is who is a child, right? And that is an issue that jurisdictions across the globe have tried to understand. We've had COPA put it at 13. We've had EU put it between 13 to 16 after intense debate to give member states that sort of flexibility. But those legislations were also backed with extensive stakeholder consultations, right, where they try to understand what is a child's development capacity like. I want to first bring in Dr. Coombs on this issue to lay out the principles of, who is a child, and then we'll come to Mr. Gogoi to, understand what are the kind of capacity issues for children we should consider while determining a digital age of consent.
Thank you, Trishi. And look, this point is going to be, I'm sure, regarded as somewhat provocative, but I find it a contradiction that countries can view children as being capable of having the capacity to know right from wrong at the age of 7. And this varies across countries. In my own country, Australia, it's 10. And if they can be seen to be as being capable of distinguishing right from wrong at such an early age, but they are not able to make a decision about the processing of their own data before the age of 18, seems to me to be problematic. And it really highlights the fact that how we define a child depends very much upon the purpose for which we're regarding it and the conceptualizations that we bring to that particular purpose. And the points that I just would like to make is that the conceptualization of a child in this bill seems to lean very much towards a child as not having the capacity. And what I would like to see between the PDP, the 2019, but also the recommendations of the JPC, is to recognize much more of the CRC's orientation towards evolving capacity. And this is a very strong element of the CRC, but in also all of the general comments that you see is without exception, they refer to the evolving capacity of the child. And also too, I might just add, their views. And I agree with some of the matters already being raised about best interests. And I'd like to come back to that because I think it's both significant, but I also acknowledge the reasoning that the JPC said for the recommendation about dropping that particular clause. Now, what is a child? I mean, this is where we need just to orientate to what is a child and their being the full bearer of human rights. If you are the full bearer of human rights, it's not an issue of saying, oh, well, we will grant you this right when you become of this age. It is, you already have that right, but we have to orientate our thinking towards, well, why do you need protections and special considerations at earlier ages? And this is why this notion or this idea of evolving capacity is so critical, and particularly in this context, because I really liked the point that was made by two speakers, say my pronunciation, Mr. Goji and Sunil Abrahams, about how children influence and bring others online. This is so very, very true. And if we're only seeing at the age of 18 that they have this capacity, it's out of alignment with reality of life, but also too, as I point out, the CRC itself. I'm very happy to come back to any of those points, and there's more points that I would welcome the opportunity to make, but I'd like to involve others on that particular point of what is a child.
Rishi, you are on mute.
Thank you, Dr. Coombs, for giving us those broad outlines of the fundamentals and the principles that should go into determining who a child is. I'll come to you, Mr. Gogoi, and I want to understand how do we contextualize these, like understanding these issues like evolving capacity within children is difficult enough within a certain age group, right? How do you contextualize this in a country as heterogeneous as India? You know what? Because a regulatory approach also needs some uniformity at some level. So how do we sort of factor in for this heterogeneity, especially because it has such deep implications on the rights of children in other areas like freedom of speech and expression, freedom of association, freedom to access information.
Trishi, here's again is a classic case of where the government, and especially in this case, the Ministry of IT, had they coordinated a bit more on this particular subject with the Ministry of HRD and Ministry of Women and Child, they would have understood the concept of childhood, right? Because if you look at it from an educator's perspective, you have early childhood education, you have childhood, you have adolescent education, you have youth, and then you have adult, right? So there is a clear demarcation that in the education policy space that we have between 0 to 3 years, 3 to 8 years, 8 to 15 years, 15 to 18, and 18 plus. So, and whereas in this bill, we've been a bit lazy and said that, 18, everybody below 18 is a child. That's not the case. You can't go from child to adult straight away. What happened to adolescence? What happened to youth? So, there was a talk at that point of time during the JPC that we should lower the age. I do feel that this is somewhere that even if the government comes up with a bill that initially says 18, it would just by practice evolve, and it might come down anywhere between 2 years to 3 years. I do see this coming down because it's not practical. No 16-year-old, whether from a rural part or an urban part, would want their parents to give consent to them for their own Facebook accounts or Snapchat accounts for that matter. So it's a bit I think it's one of those legislation parts of the legislation which is work in progress, where you put the design out. It's a draft design. You kind of go on the overreach, and then through practice, you are able to nuance it, and you're able to sharpen it a bit more. But as I said, I think clearly, there's enough experience in the Indian government of how to work with children, and in the entire capacity of child rights and child capacity. That knowledge, that understanding, that sensitivity already exists. We frame policies around that. From an education, we understand the different skills that children have at different age groups. We design a curriculum based on that. Our curriculum is uniform. So I think that's where we could have been, a bit more comprehensive, and I'm hopeful that this is something that would, would to put it very crudely, sort itself out in the near future.
Thank you, Mr. Gogoi. Just to supplement your point on, on the educational policy recognizing it. In fact, the guidelines by the Ministry of Women and Child Development also recognize this in the context of online harms. So, where they're talking about what kind of harms are going to be accrued to children of certain ages, there is the same age division that is made, which is 0 to 6 years, then 7 to 12, 13 to 15, and 16 to 18. So it's not that this evolving capacities framework is not provided for in other concurrent legislations that we have. It is just that it seems to be missing from the PDP bill, right? And coming to you, Aprajita, can you just outline for us the kind of implications this lack of evolving capacities will have on children's adjunct rights right of freedom of speech and expression, etc.
Yeah, Rishi, sorry, if I can just add to the policy frameworks that we already have. There's also the child labor law, which allows employment of children above the age of 14 in non-hazardous environment. So we've already dealt with that differently in some other law. Plus the Juvenile Justice Act, there was a lot of discussion around how children may be treated differently between 16 and 18, and the court determines the maturity of the child. So I think those discussions can also be drawn upon if the government wants to take a more considered view of where should this age of independent consent should be. The second thing, what kind of impacts it can have on children. So I think, generally what we see, there's a huge digital divide, and I think everybody's spoken about the fact that many children are in fact bringing adults online. I mean, I actually worry more about the gullibility of elderly on the internet, because they are more prone to cyber fraud and the kind of things that my grandmom posts on Facebook. I often have to call her and be like, please delete this, don't share this information on the internet. So I think age anyway, is that a good indicator of your digital maturity? Maybe not, but I understand that you can't make I guess like a separate law for elderly. But I think there can be tools in the future, and I think the age appropriate design code alludes to that, which can help you establish the maturity of a user on the platform. And then depending on that, certain default settings, etc., may be prescribed to the user already. On what kind of impact it has, I think children's agency is very important, because a lot of children's parents are not using the internet, and therefore they may not be able to make that kind of decisions. Plus it can, what about privacy at home, right? I mean, in Indian culture, privacy at home is anyway a bit I guess at risk, generally. And that gets amplified when we talk about children who may have a different sexual orientation, or people who are discovering their identities, or maybe going through some mental health crisis, and they do not want to kind of, or even sometimes parents can themselves be causing harm to the child, so they may not be able to reach out to an online community to seek help if we are able to actually implement this provision. While what Mr. Gogoi is saying is correct, that right now in this with the technology that we have, we may not be able to even implement this provision really well. But if we are able to implement this provision, then you may be actually putting some children at risk. And I think some other jurisdictions, for example, in the German law as well, they have said that privacy in all environments need to be protected. So it's not just online, also about the home environment. The other thing that we have to think about is gender. And I think Dr. Coombs also mentioned this in her opening remarks. Already we see a lot of digital divide among men and women in India in terms of access to digital devices itself. So if we start giving so much power to parents in a very deeply patriarchal society, we may be cutting off more girls from the internet, and therefore not giving them the same rights as men. So all these things also need to be taken into account. The other thing is, we also are competing in a very global environment. So if everybody else is making 13 or 14 as the age of consent, we are keeping away, we are not offering the same opportunities to our children, but they have to compete in a global economy eventually. So do we not want them to be as digitally savvy as the rest of the children in the world, is also something that we should think about.
Thank you, Ms. Bharti. I think those were some very valid points, but the main takeaway from this is, what if the law is well implemented, because that creates a monster in its own capacity. As Mr. Ibrahim pointed out, it leads to concerns of data maximization. It requires the age of the user to be verified. It requires parents' identity to be verified. And there are different standards also to, this consent. So for example, COPPA says it needs to be verifiable parental consent, right? Which means that at any point, a service provider should be able to verify that valid consent had been taken from the parent. As opposed to this, in the EU, they say you should take reasonable efforts to verify parental consent, which seems like a one-stop mechanism. In India, that clarity is still lacking. We don't have it as clearly worded in the PDP bill. But despite those differing standards, I think there is a baseline concern with data maximization. And if Mr. Ibrahim, you could, sort of talk about how, as you mentioned, this goes against the principle of privacy, where you collect more data to ensure somebody's privacy.
Before I talk a little more about the data maximization contradiction in the approach that the bill takes, I wanted to continue on your earlier question, which is, who is this child that we are talking about? And I wanted to break away a little bit from the temporal hegemony, which usually frames those definitions. Aparajita has already spoken about the girl child. I think that's a very important point that she's made about disparate impact of a law like this, even though that is not the intention at all of the policymakers. Just because a law that does not specifically recognize deep-rooted patriarchy, it basically means it will have very disparate impact when it comes to both male children and female children. The second thing is, the child, at least a lot of them, millions of them, are poor children. I was looking at this infographic that has been produced by India in Pixels, and they were talking about the number of years of work that needs to be performed before a person is able to purchase the latest iPhone. And for 216.5 million of India's rural poor, that stands at 7 years of labor in order to purchase an iPhone. So what the bill is doing with its blanket prohibition of all advertising targeting children is the bill is discriminating against gratis service providers. So there are two business models on the internet. The first is subscription-based services, and the second, like most of Meta's products, are gratis or free of charge services. Ideally, the bill should have taken the approach to regulate advertising targeting children in the best interest of the child. If that is not the approach adopted, then gratis service providers can't serve children, and therefore children will find it more difficult to access all these services online. The next frame is the child. I spoke about the empowered child with clear evidence of agency, but there is also the vulnerable child. If there is blanket prohibitions on monitoring and tracking, then the variety of safety features that we have on our platforms to prevent children from getting into danger, to prevent predators from approaching and communicating with children, all those safety features will also have to be turned off to be in compliance with the law. So there are a series of unintended consequences emerging from what Uttara Ganesh described as the one-size-fits-all approach that is clearly in the bill as it stands today. So going back to data maximization, I'm going to pull my 12-year-old daughter into this conversation. She's a heavy user of a whole series of apps, and she experiments with apps that I don't always get an opportunity to research and check out completely. But the vision of the future is that on her phone, with the 20 apps that she uses, every single app is going to have a copy of her ID and my ID in order to verify our relationship and her age. And that exposes not only her, but also me to ID fraud. So while having ID or KYC is perhaps critical for certain types of service providers. Perhaps a video or an image editing app should not be the app that collects your ID documents. So I wouldn't want to make a blanket statement one way or the other, saying that this is or isn't appropriate. For all apps targeting children, some of it is and some of it isn't, and it really boils down to a more granular approach to solving the data maximization challenge.
Right. Thank you, Mr. Ibrahim. It's, very interesting to know that not only do children require a heterogeneous approach with respect to, evolving capacities and, as has been pointed out, multiple childhoods that they experience, but also the services that are being targeted under the bill, right? Because sometimes it seems like this is more of a content regulation approach which is being taken rather than rather than the risk from data processing that we're trying to avoid. But the blanket ban on profiling targeting, as Mr. Ibrahim pointed out, has significant implications on gratis services. But even apart from that, and Ms. Ganesh, I would like you to come here. I think it makes functioning of online service providers completely impossible, because the ban is on any kind of profiling. So even within a user session, if somebody is tracking your cookies just to, let's say, verify your age, that you go to the other page and you don't have to do that age verification again, that is also prohibited under this bill, right? So, and this is not an approach that's being seen in other jurisdictions. So for example, the EU does not prohibit any special kind of processing specifically for children. It generally prohibits automated decision making, etc., but nothing specific to children per se, right? So could you just, in a minute or so, elaborate on the concerns that arise from such overbroad phrasing of the law?
Sure, absolutely, right. So I think on the blanket provision on, the DP Bill currently prohibits organizations from profiling, tracking, or engaging in behavioral monitoring of the child. That's how it's phrased currently, right? So of course, it's a bit all-encompassing. And I think there is an opportunity for nuance here, right? For example, could we explore making this applicable only to the sensitive personal data of minors, for instance? Or for instance, could we place a restriction on sharing this information with third parties, right? So these are two things that stuck out to snap when you were looking at this particular provision. Blanket, broadly drawn, but there is perhaps, globally a discourse on targeted advertising generally. And maybe the way to treat this is with some nuance. So as I said earlier, can we make this applicable only to SPD of minors? Could we make sure that platforms don't share this information with third parties? Right. And something we also do with Snap is, again, we have a policy against targeting certain types of ads towards minors. So that in a sense can also be, again, a preemptive design or data management type intervention that can solve for this particular problem. So yeah, I'll stop with that.
Thank you, Ms. Ganesh. I think one of the interesting points that we came across was sensitive personal data, right? So even though in the marginal note, the bill refers to sensitive personal data for clause 16, there is no mention as such within the provisions of clause 16 about sensitive personal data. And for that, Dr. Coombs, I would like to come to you and ask you what sort of differential approach do you think is it required or not when we deal with sensitive personal data of children, right? So as you pointed out, because of the pandemic, health records have been increasingly digitized, learning outcomes have been digitized, and given the potential time that they will be collected over, an adult's data set will be much lesser than what a child will accumulate through the years, right? So do these special kinds of sensitive personal data require certain protections that are different from what we're currently seeing for adults right now?
I think that's a very valuable point. And to my mind and the work that I've done, there are some aspects or characteristics, identifiers around individuals which are particularly sensitive, and that can change from country to country, culture to culture. And they certainly do require the ability for it to be protected. And at the moment, for many people, it's gender, gender orientation, gender identity, and diversity in gender. And those ones in particular are ones which children have identified as being ones which they not only want to be protected for themselves, but they also wanted to see to be protected in children that they have observed discrimination and violence occurring to. I'm actually just going to cut to an issue which Sunil raised, and that's about anti-discrimination or discrimination. And I'm going to come back to your point too. But one of the key elements of the Convention on the Rights of the Child is the right not to be discriminated against. And I'm not sure how the PDP actually puts that into effect. One example that occurs to me as yet another unintended consequences, and there may be better examples, including the one about sensitive data, is that if you have children, and I'm particularly conscious in India, there might be those whose birth were not registered before the year of 2005. If their birth has not been registered or has been inadequately and incorrectly registered, how then, and if there's no guardian or parent available, how then do they prove that they are now in a situation where they can give consent? These are bringing elements of discrimination, which I think are very important, particularly when you start to look at the numbers of children who fall into those vulnerable situations. And I'm going to take this opportunity too to go back to an earlier point, and this is about the issue of chronological age, because I'm very concerned that this point should not be missed. Using age is a very convenient mechanism. However, it is a very blunt tool, whether it's 13 to 14, 13 to 16, whatever it is. I think it needs to be noted in this context here is that some countries are actually using capacity, not chronological age, as a way to gauge whether a child can give or can take certain degrees of decision-making responsibilities in certain circumstances. And that was one of the points which I included in the report that went to the UN, and that was information gauged from the Global Privacy Assembly, which is the international body for data protection authorities, whose work that they looked at this issue of children and that issue of capacity as compared to age. Now, just back on your issue of sensitive data, many data regulation frameworks around the world do not include gender. They might include sex and they might include sexual orientation, but gender has been something which generally has not been adequately reflected as being a sensitive matter. And if we should think about the issue of sensitive data, we need to be very careful about not picking up already existing definitions of that category of data because they are not particularly inclusive in all cases. And just finally, if we have restrictive regulation of children's right to consent to their processing of their personal data, including their sensitive data, that restriction may also impair their holistic development as a person. And this is some of the issues which we need to acknowledge is that this area, there's a lot of interrelationships between various rights and various consequences. And so even with the very best of purposes, we need to be very attuned to how this will work out in practice by listening to, obviously to designers, but also in particular to children, to parents, and to those who are actually on the front line. I'm conscious of time, so I'll leave it there.
Thank you. Thank you, Dr. Coombs. That was, very interesting to know that the categories of sensitive personal data themselves evolve and they're not static and they shouldn't be taken from, what the legislation provided for 20 years ago, 30 years ago. But I think a lot of our conversation today has also focused on harms arising from private entities to the privacy of children. And I want to diversify this conversation a little bit and bring in Mr. Gogoi. Sir, as you mentioned in your dissent note, right, surveillance is one of the weaker points of this bill. And it becomes especially more problematic because surveillance powers are not mitigated or regulated for children also, right? So in the context of children, do you see these sections to become more problematic than they are already?
Um, so, I mean, first of all, I want to really push this point that it is not only for surveillance, which is clause 35, which grants the government a lot of exceptions. But as I mentioned in my dissent note, which is clause number 12, which is provision of social services, also grants the government exemption. And therefore, we are in this strange scenario where privacy has been granted a fundamental right, but it seems to be in this bill a fundamental right that the government or the state is not committed to fulfill, or the state is absolved from its responsibility, whether that's from a national security perspective under clause 35, or whether it is for the convenience of clause under clause 12 of providing a social service. So therefore, when we come down, narrow it down to surveillance further, we also have to understand that our surveillance regime, the statutes which are on the books are quite outdated, and they need to be updated, especially in an era of modern surveillance. We, our acts are from the Telegraph Act. We are still using the Telegraph Act and max to max an IT Act of 2000 for surveillance, which is going on, the kind of surveillance technologies and platforms which are available right now. So surveillance as a whole also needs a reform, a complete overhaul. And therefore, obviously, when it comes to children, as you have facial recognition, as you're capturing Aadhaar data at every step, the entire concept of privacy, whether it's for children or of an adult, but the concept that even the Indian state has to uphold certain standards, I think that has completely gone for a toss, and that's been a major source of dissent for a lot of parliamentarians, both within the JPC and outside of the JPC.
Right. Right. Thank you. So I think this issue becomes more important. As we said, we talked about how, varied fields of data is being collected. Schools are partnering with e-learning platforms now, and all of that data is going into one data set, and there is no sort of regulation on that. Ms. Bharti, just as you pointed out, you want to make a comment on the ban on profiling from an industry perspective. Could you comment on that, please?
Right. So, Trishi, I think, when we talk about how it will impact industry when there is a blanket ban on profiling of children's data, I think we are often talking about the big tech companies like, Facebook and Snap, etc. But think about the startups, right? If I am somebody like, for example, Vilac has database of only 1,000 children, right? And if I have to make a product for them, or if I want to offer any service for them, if frankly this PDP bill gets implemented in this thing, I would rather not be in that industry, because I think the liability that comes with developing a product for children is so much with this bill that you rather ignore that target segment altogether. So if you look at all these micro decisions and then look at it all together, then basically you are stifling innovation for children's products. So it's not just your immediate rights that you are curtailing, but also the innovation ecosystem for children is getting curtailed, because you're coming from such a place of distrust on everybody who's trying to make products or services for children. And these companies, many of these companies may not be even tech first companies, right? When we're talking about data, we're just talking about ed tech and For example, social media companies right now, what about schools? What about, small coaching centers, etc.? They've all gone online because of the pandemic. And they do not have that kind of sophistication, the legal teams, the compliance teams that some of these billion-dollar companies have to be able to comply with the law. So are we by design making a law that we know nobody will be able to, actually comply with? Or are we not? This is also an unintended consequence of the bill that I think is less spoken about.
No, absolutely. And, in fact, the Irish Data Protection Commissioner focuses on the point that age barriers or age verification mechanisms should not be a way for online service providers to denigrate the experience of minor users, right? Because that itself restricts access to information to a large degree and discriminates against the child. So absolutely point well taken that a lot of these discussions focus on tech and data industries, but data processing is happening at every level, just from a pure data management perspective, right? So not necessarily profiling, etc., which all gets covered into this. Definitely. Coming to you, Mr. Ibrahim, and this is something that flows from this point, right? How do we avoid these extreme solutions? How do we manage to create a regulatory solution or a regulatory framework and environment which does not swing to these extremes of, as Mr. Gogoi pointed out, being extra protectionist or, not caring for privacy at all?
I think the global approach, and this is how I understand the GDPR as well, to solve for regulation and to make regulation sort of future-proof is to ensure that the high-level principles are in the parent law, and that the parent law has a framework for co-regulation, wherein sector-specific standards are developed by very specific sectors in the industry. Those standards are then bubbled up to the regulator. The regulator then, through discussion with stakeholders, finalizes these standards and brings them formally into the co-regulation framework. And then the regulators' carrots and sticks are used to enforce the co-regulation framework. So that's the way I have seen it solved. You want a law that is not quickly outdated, but at the same time is dynamic and is specific enough so that the edtech sector has what they need. And even though Uttara says that social media is a bad umbrella term, perhaps streaming services have what they need, and so on and so forth. So even if you have to go more granularly, I think a co-regulatory framework is the best way to solve for this from a regulatory design perspective.
Yeah, no, definitely. And one of, the recommendations that academicians also put forward is that the capacity of the child should not be seen as to the general digital environment, but, whether or not he has capacity to consent to data processing in that context. And those contexts differ with different services. So absolutely point well taken. It helps to build a more granular approach. It helps to build a more evolving approach to privacy issues. I think we can end here. I want to thank all our panelists for this extremely delightful conversation. I think despite having worked on the paper for so long, just from this mere conversation, I've learned a lot on what goes into what the perspective of a policymaker can be, as Mr. Gogoi elucidated, and what the industry sort of expects from a data protection framework, and also how within that continuum do we provide for children as right bearers in themselves. So a big thank you to all of you for joining us today. And we hope that we keep, collaborating and continuing our conversation on these issues. Thank you.